Okay, well, welcome everybody to the University of New Mexico Law and Mental Health Didactic Series. This is a weekly series hosted by the University of New Mexico Department of Psychiatry and Behavioral Sciences, along with the New Mexico Behavioral Health Services Division. We're very thankful for all of you that are coming into attendance today. I'm Dr. Anthony Perillo. I'm the Forensic Psychology Training Director here at the University of New Mexico in the Department of Psychiatry and Behavioral Sciences. For next week's talk, we have Anthony Perillo, me, talking about biased clinical judgment in forensic evaluations. Can anything really be done about it? But for our talk today, as a heads up, if you have questions, make sure you ask them in the Q&A box, not the chat box, the Q&A box, anytime you feel comfortable. We will not be getting to the questions until the end, and we try to do our best to get to as many questions as possible. Just forgive us if we don't get to yours. For those of you that want continuing education credits but are on a tight schedule, you do have to stay for the full hour, but you don't have to stay longer than that. We'll let you know when the hour is passed. You can stay longer for questions if you would like. For those that are interested in continuing medical education credits, there will be a sign-in sheet in the chat box. In the last 5 minutes, we will have a link that'll be posted in the chat for continuing education credits for APA. Note that you need to open up that link before you leave this talk. You'll want to open that link to save your certificate after you complete the survey, because we don't keep those on record. The recording, a link and a PowerPoint to this will be available to you in about a week. And let's go ahead and get started. I'd like to introduce you to our speakers for today, who will be discussing issues of fetal alcohol syndrome in the criminal legal system. We have Professors Michael Perlin and Heather Cucolo. Michael L. Perlin is a Professor of Law Emeritus at New York Law School, where he was the director of the New York Law School's online mental disability law program and director of NYLS's International Mental Disability Law Reform Project in its Justice Action Center. He's the co-founder of Mental Disability Law and Policy Associates and is currently an Adjunct Professor of Law, Emory University School of Law, and Instructor at Loyola University New Orleans, Department of Criminology and Justice. He's written 33 books and nearly 300 articles on all aspects of mental disability law. He's litigated at every court level, from police court to the US Supreme Court, and he's done advocacy work on every continent. He's the honorary life president of the International Society for Therapeutic Jurisprudence and a member of that society's current Board of Trustees. He's also a member of the Lawrence Township in New Jersey Community Concert Band, the Temple University Night Owls Band, and the Board of Directors of the Washington Crossing Audubon Society. We also have Heather Ellis Cucolo, who is a distinguished adjunct professor of law and the facilitator of the joint JD MA program with John Jay College of Criminal Justice at New York Law School. She's also an adjunct professor in the JM program at Emory University School of Law and a fellowship faculty member at Albert Einstein College of Medicine. In addition to those roles, Professor Cucolo is co-owner of Mental Disability Law and Policy Associates, a legal education and professional training company, and was elected to the Board of Trustees for the International Society of Therapeutic Jurisprudence, a nonprofit organization. Formerly in her full-time legal practice, Professor Cucolo dedicated her career to representing individuals at trial facing civil commitment under both New Jersey mental health hygiene laws and New Jersey's Sexually Violent Predators Act. She authored and argued appeals before the New Jersey Appellate Division with over 27 reported decisions. She's published 4 textbooks and over 21 law review articles with mentions in an Eastern District of New York court decision and an Iowa appellate decision. She was honored to receive the Otto L. Walter Distinguished Writing Award for 2 consecutive years in 2018 and 2019. Professor Cucolo's international work has included expert testimony on extradition from the United Kingdom to the United States for persons convicted of sex offenses, pro bono advocacy for Law Aid International, speaking at the United Nations on the rights of persons with disabilities in the Asia Pacific region, and the creation of an instructional course on disability legislation for attorneys in Japan. Michael and Heather, on behalf of the University of New Mexico, can I just say we're very excited to have both of you joining our series and thankful for you to share your expertise with us. I am now going to turn it over to you.
Anthony, thank you so much, and it's really a pleasure for both of us to be here. That, and we have no financial agreement. So as Anthony told you, we have lots and lots of experience in representing people with serious mental disabilities, with developmental disabilities. We've written about fetal alcohol syndrome in this context. And this Monday, we agreed to publish an article in the University of Miami Law Review, from which many of the PowerPoints in this presentation are taken. That article is called "Take the Motherless Children Off the Street." It's a Bob Dylan quote, which is usually the source of the beginnings of all my article titles. Fetal alcohol syndrome in the criminal justice system. If you're interested, it's footnote 1 here, and it's available on ssrn.com for free and easy download. I'm going to start with the introduction. Heather will then talk about the science of FASD. She's going to lateral it back to me to talk about expert testimony and counsel, and then competencies and insanity. Heather will then again speak about sentencing and the death penalty, and I will then talk about therapeutic jurisprudence. And you heard from Anthony's introduction, this is something we're both very, very much involved in, and a very short conclusion. I want to begin this way by talking about Latvia. I used to do a lot of pro bono work and advising for a group that was then called Mental Disability Rights International. It's now just called Disability Rights International. And in the year 2000, December of 2000, by the way, Latvia is very cold in December, I went with my colleague Eva Selly to Riga, where we went to the Latvian State Hospital. We're given the usual visitor's tour, and we walked by a classroom. I asked the tour guide, what was that? She said, oh, those are our students. I said, we'd like to see it. She opened the door, and the students, who were, I guess, but somewhere 10 to 12, 12 to 14, saw us and all stood at attention, which freaked us out. And they stood while we talked to the teacher. I said afterwards, why are they there? And the tour guide said, well, they all have fetal alcohol syndrome. They'll be here for the rest of their lives. And, you know, I was kind of in a daze after that, but it made me think, boy, this is something I need to know a lot more about. Fetal alcohol syndrome wasn't mentioned in any legal case until 1981. There's no citation to those words in any legal academic journal until 1982. The article that Heather and I are going to be publishing next year that I just mentioned is the first full-length law review article from an American law school's law review ever. There's been minimal literature about all of the issues we're going to be talking about, and we hope that today's webinar gives a flavor of what we are interested in. I'm now turning it over to Heather, who's going to be talking about the science.
Excellent. Give me 1 second. Thank you, Michael. All right. Yes, as Michael said, so I would assume that a majority of the individuals who are participating or listening today are familiar with the science behind FASD. So this is going to be very basic and pretty much, you know, for the time constraints, all we can do is somewhat basic, but understand that the information that I'm going to provide with regard to the science really sort of sets up an understanding of why these issues are so significant and so complex when we merge it into the criminal justice realm, field, etc. So the origins of FASD and fetal alcohol spectrum disorder really more or less refers to the range of birth defects that result from prenatal alcohol exposure. It includes several subclassifications, and the consensus seems to be that there is no cure for FASD. So more or less, once an individual again has that diagnosis, those deficits are with them into adulthood. And FASD can be worsened by and further perpetuates the financial and legal and interpersonal and health disasters that often will accompany poverty. So understanding that these individuals really start out in life, you know, at a disadvantage. So persons with FASD, generally, right, when we look at sort of the overall profile, they struggle with limited intelligence, poor social judgment, impulsivity, the inability to learn from experiences, trouble understanding social cues, etc. Now, persons with FASD typically do not make connections between cause and effect. They struggle to anticipate consequences and or fail to exhibit empathy, take the perspective of another person. Once again, what we're talking about here, and this, again, very generalized but particular in many respects, look at individuals with FASD, these elements are certainly issues that come into play in the criminal justice realm, right? Lack of empathy, one in particular, that we'll revisit down the line. Now, studies have suggested that between 1% and 5% of people can be diagnosed with FASD. Recently, I was reading an article, and if anybody's interested, I can certainly provide the information, that had some more of a different take actually on, again, obviously FASD has been forever associated with issues of, drinking, alcohol consumption during pregnancy, and thus the resulting neurological defects or developmental defects that result. Although, again, this article was sort of expressing that it's interesting to see, looking at, I guess, a cohort, a population, and saying, whatever we can know about what's being reported as to the alcohol consumption, certain individuals are not affected, in vitro, whereas others are severely affected. And maybe in certain scenarios, the amount of alcohol consumption is very similar. So again, what we have from our studies, 1% and 5%. Underreporting, right? Underreporting affects accuracy number. Obviously, why is there underreporting? The shame, potentially individuals, again, who are in a lower socioeconomic cohort, maybe not being able to be identified as easily in more rural, maybe areas, and more areas that are not as commonly sought out in some of these studies. Experts fear in recent times that COVID-19 had a significant impact because of the greater use of alcohol, and potentially could contribute to a higher number of cases involving individuals with FASD moving forward. Now, Native Americans, Alaskan, Eskimo, Inuit peoples thus far it's believed, have some of the highest rates of FASD among various ethnic groups, that, according to our source or sources, followed by African Americans in this country. Fetal alcohol syndrome, it's going to be used in the case law scholarly articles, and it's used interchangeably oftentimes, particularly by those that are not psychologists, experts in this area, but it'll be used interchangeably with the FASD, the fetal alcohol spectrum disorder. But understanding, of course, that FASD is this broad umbrella, and it includes a wide range of neurological and behavioral problems. And distinguishing the FASD delineations, it is accomplished, it's achieved by looking at the very particular symptoms that are identified and thus diagnosed in each individual. Each individual has to be looked at, obviously, as in reference to their particular deficits or their particular abnormalities that are being noted. And so when we look at under this umbrella, right, and we think about the FAS, fetal alcohol syndrome, generally, when the diagnosis is FAS, it is because the presentation of the fetal alcohol harm is most severe. And it can be diagnosed through an examination of factors such as height and or weight, less than the 10th percentile, unique cluster of facial abnormalities, severe structural, neurological, functional abilities, extent of the prenatal alcohol exposure. But again, right, how much are we aware, or how often are we assured? Is there any real evidence of the extent of that prenatal alcohol exposure? Now, just bringing this back, of course, to the legal realm, understanding that attorneys, most likely, for the most part, have no idea what to look for and what sort of to clue them in that there may be a possibility if that diagnosis isn't already contained somewhere in the record. So that's going to be a significant problem. Because why? Because attorneys, as Michael's going to talk about soon enough, when we think about, how are we going to handle a particular case? What type of expert do we want to hire? First step is we have to identify what some of the issues could potentially be. Again, under this umbrella, right? I did just talk about, the most severe in terms of how it presents itself, which is FAS, but there's also partial fetal alcohol syndrome. And that's going to be diagnosed when someone is lacking in one or more of the criteria used to evaluate the FAS. But of course, there's still a presentation of various physical, emotional deficits. And of course, there's alcohol-related neurodevelopmental disorders. That's where there are outward physical abnormality. The outward physical abnormalities are not there, right? They're absent. But again, there's a documented central nervous system abnormality and a other type of cognitive behavioral problems. Now, even again, a layman or an attorney, let's say, who has even some amount of knowledge in this area, certainly these manifestations can be confused with or misdiagnosed as a multitude of other types of disorders, right? And really focusing in and identifying, fetal alcohol syndrome and under the spectrum is something that's going to be crucial to really getting into the heart of any type of mitigation or any type of issues of showing how the individual may not be as culpable. Now, these two in particular, PFAS, ARND, they happen to show the most severe secondary disabilities, right? Secondary disabilities clearly being like the intellectual, the cognitive behavioral, some of those elements. DSM-5, right? How does, and again, I would assume that a majority of the individuals that are present today have a better understanding or at least a working knowledge of this information, but the DSM-5 references FASD as a central nervous system dysfunction, brain damage in essence, and as a neurodevelopmental disorder that's associated with prenatal alcohol exposure. The DSM-5 designates the prenatal alcohol disorder as the mental health diagnosis for fetal alcohol syndrome disorder, or fetal alcohol, without requiring the presence of that, physical abnormality, the facial abnormalities, growth deficits that are, as I had mentioned on the previous slide, most commonly often seen in FAS and necessary in diagnosing FAS. And thus, though, under the DSM-5, it recognizes that there is no real consistent difference in scope or degree of brain damage among the various FASD medical conditions. This information, right? This is something that, again, may make it very difficult for attorneys, persons representing someone who either has been diagnosed or suspected of having fetal alcohol syndrome, right? This is something that, again, may be information that's very difficult to sort of, flesh out, understand, and then be able to use this information, be able to explain this information to the court, and seeing how the different diagnosis and the different analysis would fit into a theory of the case. Okay. Intellectual disability. So FASD has clearly an increased risk for intellectual disability, but it may not be the most typical presentation. This I'm going to circle back to when I talk about sentencing and death penalty in particular. FASD, known as the invisible disease, because it oftentimes is overlooked, or it's mistaken, or it's diagnosed as something other than that. All right, typical presentation. We have, by the way, as you'll see, all of these footnotes, all the sources are contained at the end of the PowerPoint. So if anybody needs more information or wants to take a look at any of the information that we're providing here, it is all there for you. We have behavioral characteristics. Once again, the purpose of these is you look at like impulsivity and you look at superficially communicative, exaggerates to impress, wants to please. We're looking at this now through the lens of the legal system and how some of the characteristics may cause a real significant problem when that person then interacts with the legal system, right? Impulsivity, these types of characteristics, inability to recognize risk. If someone's overly suggestible, maybe gullible, right, that's going to have the potential to impact all the stages of the process. And that goes from arrest all the way to sentencing and punishment. For example, we see, and this of course was present, once again, I'll circle back to the case of Atkins versus Virginia, where the Supreme Court said that an individual who has been classified as, the language used was mentally retarded. Of course, now we know that's no longer the appropriate language, but those individuals cannot be executed, right? Because it's a constitutional violation of the 8th Amendment, cruel and unusual punishment, right? So, right, this idea though, by the way, the story of Atkins, the individual was very susceptible to the co-conspirators in the crime that was committed, very susceptible to just, doing whatever his peers would tell him to do. And that sort of obviously causes a problem if we're talking about criminal activity. False confessions, certainly, right? If an individual is tending to want to please or overcompensating for their ability to understand. And we see this, again, not just with FASD, we see this with a whole slew of other types of disabilities, but false confessions, whether or not they are actually going to understand their Miranda rights, whether they're going to understand the consequences of what they say, how they act or react. Even just generally speaking, right? Maybe issues of remembering the bail conditions that they have to abide by, or particular dates that they have to attend as a result of being involved in the criminal process, and obviously the punishment, the sanctions that would flow as a result of these failures. At this point, I will turn it back to Michael.
Okay, thank you. Okay, so why is expert testimony so essential? And I see there are 405 people here, which is pretty awesome, I think. A good number of, it's remarkable. A good number of you must do expert testimony. Why is it so important? Well, think about what the public, fact finders, both judges and jurors, what do they know about the criminal justice system? Their knowledge base flows from TV news, from internet websites, and it's dead wrong about almost everything the public thinks it knows about matters that are so important within this system. Why are they so askew? Overuse of heuristic cognitive devices, the vividness heuristic being the most important example. They know about one case in which XYZ happened, therefore XYZ happens in all cases. The use of ordinary common sense. I see it this way, therefore everyone sees it this way. I see it this way, therefore it is. And judicial biases. We know, and there's lots of empirical work on this, that judges treat biologically based evidence, and this is certainly that, in criminal cases involving mental disability law to conform to their pre-existing positions. So experts are especially needed. Now, what's interesting is this, the Bar Association has said in its guidelines in death penalty representation, and I should have bold-faced or underscored or both the words death penalty there, because these guidelines are applied to death penalty cases, and many courts have said, oh, this isn't a death penalty case, that doesn't count. That to me is inexplicable, but it's there. But the ABA says that FAS or FASD, whichever they use, it has to be considered as a mitigating factor to explain permanent neurological damage and the effect of these impairments on the client's judgment and impulse control. Heather has spoken to you several times already about impulsivity, and it's here all over the place. So what about the quality of counsel? Well, a recent survey article says that legal defendants are susceptible to peer pressure, easily manipulated, difficulty understanding consequences. Heather has told you about that. What impact does this have, / what impact should this have on the lawyer representing this individual? And courts are not likely to overturn convictions in cases where counsel has failed to adequately explore its ramifications. The reality is counsel's performance is appallingly inadequate. I recently did an article with a colleague who's a criminologist, Talia Reutberg-Harmon, about counsel in cases involving competency to be executed. And I said the case law is bizarre and frightening. Those are strong words to use in a law review article. That errors, egregious errors involving ineffectiveness of counsel are often ignored. And the courts rely on Strickland v. Washington to reject these arguments. Now, when Anthony introduced me, he said I've litigated at every level from police court to the US Supreme Court. I second sat the Strickland case. I didn't argue it, but I was the other guy at counsel table in Strickland. So this is something that I've been living with its aftermath for 40 years. A defendant is entitled to a reasonably competent attorney whose advice is within the range of competence. But the benchmark is whether it's so undermined his conduct, her conduct, so undermined the proper functioning of the adversarial process that the trial can't be relied on as having been the product of such competent counsel. The defendant has to show that counsel's performance was deficient and that the deficient performance prejudiced the defense. Very often, it's easy to show the deficiency, but the court must say, was this prejudicial? In other words, would this defendant have been convicted even if the lawyer had done these things that appellate counsel is talking about? And that's the issue in a nutshell. Justice Marshall dissented, saying this is such a malleable standard, it's just going to yield excessive variation in which the Sixth Amendment is interpreted and applied, and he was right on the money on that. The burden of proof here is on the defendant to prove that the prejudice caused the conviction. Think about this in an FAS case. There are quite a few cases involving defendants with FAS. I'm highlighting a few here, but believe me, there are many, many more. In Floyd v. Filson, it's a Ninth Circuit case, the court said counsel failed to present expert testimony that the petitioner suffered from this disorder, but that was not ineffective counsel. Even assuming it was deficient, the court said, there is no reasonable probability that had the jury heard from such an expert, it would have concluded that mitigating factors outweighed aggravating factors such that Floyd did not deserve a death sentence. How can the court say this? My feeling is they can't. There is no way the court could predict what was in the mind of these 12 jurors, or actually any one of those 12 jurors, had they heard testimony that they never heard. To me, that's utter fantasy. That's the Floyd case. It said at least one juror would have had to consider that this was more severe and debilitating as other problems, but without you, but the terminology never used. No one ever testified specifically about FASD. This is one of those examples to me of false ordinary common sense. How could the court read the mind of all 12 jurors saying there was no reasonable probability that the outcome might have been different had this testimony been offered? Same in the state case of State v. Johnson, the Missouri Supreme Court said counsel's failure was not deficient. The defense expert had said that his adolescent behavior was characteristic of the syndrome, but the syndrome was never explained. It was never defined. Nothing that Heather said to you in the first 15 minutes of this webinar was ever told to the jurors deciding whether Johnson should or should not be executed. I think that's significant. In State v. Cooper, and I look at Cooper because Cooper is a New Jersey case, and we both practiced in New Jersey for many years. The point is the New Jersey courts are usually among the most sensitive in the country to any of these issues. But the court said that the deficiency by defense counsel in failing to present mitigation evidence wasn't prejudicial and did not constitute ineffective assistance of counsel. Again, as far as I'm concerned, simply a totally wrong case. There are a few, underlined few, cases on the other side. Hearn versus Quarterman, a reconsideration motion was granted, saying that the counsel, if he was reasonably competent, could have concluded that the evidence of his FAS was significant and could have gotten expert testimony, the court thus granted relief. But these are very, very underscore rare decisions. Now, what makes this worse is a case that virtually nobody knows about, because it was decided either 3 days before or 3 days after Dobbs. Case that overruled Roe, so nobody paid any attention. The Supreme Court sharply limited the capacity of federal courts to consider Strickland-based evidence in habeas corpus petitions flowing from state court convictions. In the Filson case that I told you about, where Filson lost, that was a habeas corpus, an appeal of a habeas corpus denial. In Hearn, that was a habeas corpus grant, but these were both state court convictions. After Shin versus Ramirez decided this past June, federal courts can no longer hear Strickland issues in these habeas cases. Therefore, death penalty defendants with a history of FASD will be barred from claiming ineffective assistance of counsel if this ineffectiveness stems from the fact that FASD was never brought to the trial court's attention. Well, certainly the lawyer who did that isn't going to raise a Strickland issue because it's about him or about her. What about competencies? I'm going to assume that you know the basic standard black letter law on competency, ability to consult with rational understanding, a rational factual understanding of proceedings against the defendant, ability to prepare defense. And we know that the brain damage that's caused by FASD creates impairments, manifested impairments that may reduce this ability. So what impact does this have? Answer, not much. The lead case here is Dobine versus State, an Alabama state case. The defendant said his lawyer was ineffective for not investigating and presenting evidence on competency. The court says he doesn't offer any facts in the pleading to support it, notwithstanding the fact that he had an IQ of 73, a mental age of 12, that he did have fetal alcohol syndrome, brain damage as a result of alcoholism and cocaine abuse. But in this case, Dobine's lawyer never sought to have incompetency declared. The Alabama Court of Criminal Appeal says, no big deal. In Lambert v. Blodgett, a Ninth Circuit case, again, this is a federal case, counsel was not ineffective for failing to investigate a defense of FAS and said, you should plead guilty. Lambert's lawyer said, but look at everything that the ABA has said about introducing information about mitigation. I told you about that before. The Ninth Circuit said, no, that only applies to non-capital homicide cases. Defense counsel is not subject to those specific investigative obligations that were imposed on other cases by the Supreme Court. I think this is remarkable. And I think this is something that's really not known at all. I've never met an expert witness who knew this. Maybe, I'm sure some do, but I've just never met him or her. And it certainly is not known among most lawyers. In Ruckert, a state case in Michigan, the appellate court noted that the defendant had FAS. There was no error in the trial court not seeking a competency hearing, noting he had been found competent 3 years before. But if a student had given me that on a criminal law paper, they would have gotten 0 on the question, because the black letter law, which has been there for well over a century, says it doesn't matter what you were like 3 years ago. It matters what you are like on the day of trial. This is as clear a legal error. This has nothing to do with fetal alcohol syndrome, it has to do with the law of competency. It's as clear a legal error as I can see, yet the conviction was affirmed. What about insanity? Well, there's 2 issues to consider here. The issue of volition and the issue of risk. Volitional behavior is consciously, intentionally chosen. Risk involves a criminally sanctioned outcome. So if a defendant has brain-based impairments in reasoning, then question, should that defendant be totally or partially exempt from criminal responsibility? Courts have paid virtually no attention whatsoever to the presence of FAS or FASD in insanity defense cases. A state case from Washington, not an abuse of discretion, to preclude the FASD expert from testifying as to whether it impaired his ability to tell right from wrong. the expert wanted to testify that people in this category have reasoning impairments about the right thing to do in a situation with competing goals, simply saying it doesn't apply here. Other courts have found, notwithstanding of an absolute finding of FAS, it's not unreasonable for counsel not to pursue an insanity defense, and failure to fully investigate evidence of FAS to potentially pursue an insanity defense does not show ineffectiveness of counsel. There's one case I want to talk about a little bit more, a case called 2 Elk versus United States from the federal court in South Dakota. In rejecting the defendant's claim that counsel was ineffective in failing to perform a competent investigation that might have led to an insanity defense where the defendant alleged he suffered from FAS and other things, the court says, with no explanation, no citation, no reference to the record, the mental diseases and or defects which defendant alleges that he suffers from are unfortunately not uncommon among defendants who appear before the court, concluding that as a result, the court finds that petitioner was not prejudiced by any lack of investigation. Unpack that. What is the court saying? Well, this takes place in South Dakota, where we can take judicial notice. There's a significant percentage of the defendants in this jurisdiction are Native Americans. Defendants who appear before the court, what is he saying? He's saying this defendant is like other Native American defendants that I have seen before me, and therefore, as a result, there is no prejudice. I find this appalling, beyond appalling. I don't think 2 Elk has ever been cited until the article that Heather and I just wrote, an Eagle Review article. And one of the reasons I'm glad we wrote this article is I want to get this before every criminal defense lawyer in the country. What about executive functioning? Well, we have to look at this to see, does the individual have the capacity to commit deliberate crimes, intentional crimes? But without a qualified assessment, the courts and the attorneys have to recognize the impact of FASD, and they simply haven't done it. I'm not sure if they can do it. Okay, with that, back to Heather for sentencing and death penalty, and then back to me. You're muted, Heather.
Sorry about that. As I said, I'll circle back, and here I am circling back. So once again, we have the Ninth Circuit Court of Appeals. This was a case, Stegowitz versus Woodford. And this was a case, in addition, I think Michael just mentioned a Ninth Circuit case in 2004. This was also a case in 2004. And the Court of Appeals, the circuit, held that organic brain damage, and such as what we may see flowing out of fetal alcohol syndrome, and other situations that render an offender less culpable should be considered during sentencing, and that punishment should match the culpability of the offender. Michael focused on culpability, right, when we considered issues of competency, no doubt, and certainly looking at culpability in particular when we're looking at sort of insanity and how we consider culpability in the act. This, of course, is culpability as it would relate to mitigating factors at sentencing. Now, despite the Ninth Circuit Court of Appeals opinion in this matter, courts have really found more often than not that the failure to present mitigation evidence of fetal alcohol syndrome was not prejudicial to the defendant, that it didn't make a difference in sentencing in particular. A decision that denied habeas corpus relief. This case was a Texas case, Western District in 2012. This was a capital murder case. And in this case, the court said fetal alcohol syndrome, fetal alcohol effects that were actually presented here, right, presented by petitioner to this court, is at best clearly double-edged in nature because it necessarily led to a conclusion that petitioner would forever be unable to control his aggressive, antisocial impulses and would never be able to learn from his mistakes. This line of reasoning, right, this double-edged sword, is something that we see across the board, not just, and of course we're talking about fetal alcohol syndrome, so this case is exactly on point, but we see it in a whole bunch of other cases where what might be presented as a mitigating factor, again, lack of the ability to understand the extent of their actions or the extent of the result of their actions, et cetera, will be turned around and used in an aggravator to say, well, if that's the case, then this individual clearly is not going to be someone who we ever want to let back out into society, or someone who is worthy of, deserves the greatest or at least punishment to the maximum, okay? I had mentioned Atkins versus Virginia, right? Daryl Atkins met many of the characteristics, or at least had many of the characteristics that were mentioned in laying out those particular characteristics for FASD. Now, of course, we know Daryl Atkinson, not FASD. Atkins, Daryl Atkins, at the penalty phase of this murder conviction, the attorney presents one witness and a forensic psychologist to say that Daryl has mild mental disability, right? He's mildly mentally disabled, which again, the court classified as mental retardation moving forward in the Supreme Court decision. But when this was presented at sentencing, it really held no weight whatsoever, and he was sentenced to death, right? This, of course, went to the Supreme Court of the United States, as we see here. And the United States Supreme Court held that it is a violation of the 8th Amendment, executing someone who has been designated as, again, quote unquote, mentally retarded is cruel and unusual. And more in particular, saying that we must advance with the evolving standards of decency, how we are going to apply our punishments. And I think that that's key, because evolving standards of decency needs to be expanded broadly, right? Way outside of just, again, the quote unquote mental retardation, or obviously the intellectual disability, developmental disability realm. Remember, intellectual disability, it's actually in FAS, right? Not necessarily most typical presentation. In some of the other delineations underneath the umbrella, maybe, but not in one of the most severe. So if there's a reliance, and of course, clearly a reliance just by the court, but no doubt in a reliance by the attorney, purely on an IQ score as the key marker, it's going to be just as detrimental as when it was relied upon when we were talking about persons with intellectual disability. That came out of a case, Hall versus Florida, which flowed from Atkins versus Virginia, where Freddie Lee Hall was convicted of murder. It's set for execution, petitions for search of the Supreme Court. The Supreme Court looks at Florida's scheme and says that Florida, you cannot determine the standard under Atkins, right? Intellectual disability, developmental disability, mental retardation, purely within the narrow confines of an IQ score. It's just not acceptable. There has to be a whole look at the full picture, right? Okay. So if the absence, we're talking about FASD, of outward physical manifestations, right, that might occur in some of the other delineations, PFAS, et cetera, under the umbrella, right? If that's coupled with fluctuating IQ scores, then we run the risk maybe of not adequate attention to and potential diagnosis of an individual who should have a diagnosis under FASD. Again, whole host of potential limitations, yet still score within the average range on IQ tests. ineligibility for the death penalty, right? Kind of already we made the point, right? We made the point that this is the similarities in terms of capacity and ability that we saw in Atkins and the Supreme Court's determination of cruel and unusual punishment is going to be extended to the same types of characteristics that flow from FASD. Professors Brown and Greenspan, which Michael had also mentioned in his discussion, really state persons with FASD should be categorically exempted from the death penalty on the grounds that FASD is the functional equivalent of conditions already recognized as disqualifying exemptions to the death penalty, such as intellectual disability, right? The crux of the fact that it's disqualifying is because the individual is not someone who falls within that cohort that we believe should have the ultimate punishment, right? Even referring back to culpability, right? Talking about particular characteristics. And at that, right, very short, I'll turn it now back to Michael again.
Okay. So, what I want to talk about now is therapeutic jurisprudence and how that is involved in all this. And you heard from the introduction, Heather and I are both on the board of the International Society. I've been working in this area for 30 years. If you've read any of my recent articles, you see it gets intertwined into all of it. But I think if you look at its basic principles, dignity, voice, validation, voluntariness, that's what lawyers, judicial officers, and expert witnesses can best remediate the issues that we're talking about. My friends, Professor David Wexler and the late Professor Bruce Winnick created this in the late 1980s. And it basically says the law can have therapeutic or anti-therapeutic consequences. And we ask legal rules, procedures, and roles. That means statutes, court decisions, and what lawyers and judicial officers do. Can they be reshaped to enhance therapeutic potential without subordinating due process? Amy Ronner has characterized this having the 3 V's. I love mnemonics: voice, validation, and voluntariness. Like Tom Tyler's procedural justice theory, but with, I think, a little bit more oomph. It says we all have an intrinsic worth, and the key components: dignity, compassion, and always effective legal representation. That's a sine qua non of making sure that TJ is honored. And it also has to tie in with trauma-informed practice to afford examinees dignity and respect and improve the quality of assessment. Well, again, many of the people in the cases that Heather and I have been talking about were never assessed for the underlying disability. Professor Gerard Brown, who we both mentioned, comes up with these 6 different steps to come into competency evaluations. And this, as far as I'm concerned, is a TJ framework for any kind of forensic case. Early inquiry, complete record review, comprehensive neuropsych testimony, using a standardized competency measure, using open-ended self-evaluation questions, and trying to corroborate self-report with documented third-party data. This article, which is footnote 43, I think will be so valuable. What about mental health courts, specialized mental health courts? And there are 1 or 2 I know that specifically focus on it. I think we need more mental health courts that focus on this area to give litigants the voice demanded by TJ. It's something I've written about a lot in the past. Because of time, I'm just going to skip over it now. But I think it's certainly a solution to consider. Think about the scholarly focus on counsel representing capital defendants. Gather as much information as possible. And this should be common sense. This should be something de rigueur, and it's not. Police reports, medical records, birth records, pediatric records, hospital records. That's a TJ blueprint for the introduction of FASD in mitigation. The National Association of Sentencing Advocates does mitigation trainings nationwide. Those are grounded in exactly these therapeutic jurisprudence principles. The most important case here is a dissent by Justice Sotomayor in Trevino versus Davis. The Supreme Court had decided Trevino once, it remanded it so that he could try to expand and establish an ineffective assistance of counsel claim. But it didn't happen because the Fifth Circuit failed to view the prejudice inquiry holistically, and it said the inmate was not prejudiced because counsel did not investigate or present mitigating evidence on his fetal alcohol spectrum disorder at sentencing. I think this is dead wrong. I've written about Trevino extensively in an article about the Fifth Circuit and intellectual disability. Again, if anybody's interested in that article, send me an email. I'll be happy to send it on to you. We know that 3/4 of persons with FASD have been traumatized, physical trauma, emotional abuse, sexual abuse, risk of adverse childhood experiences among people with FASD is 7 times that of others. But this is all very often disregarded. From a TJ perspective, we have to look at people with FASD who have been traumatized. And I think this is something everyone needs to keep in mind. So I'm ending now. I see we have 6 questions. I want to give room for everything. A survey of case law says that courts have been dismissive of these claims. They're not taking it seriously, whether it has to do with competency, responsibility, or sentencing and punishment. TJ is ignored because the judges just kind of ignore, with no basis in fact or law, that the jurors wouldn't care. Again, go back to the Floyd case, the Ninth Circuit case, I've talked about a bit, that there was no reasonable probability that such testimony would have led the jury to conclude that mitigation outweighed aggravation. And the answer is, there is no way in the world a court can say that. It's impossible, but they continue to do so. But if we were to use TJ as a prophylactic tool, I think there would be much more informed, effective counsel in these cases. There would be more of a movement to create problem-solving courts to allow for diversion of these cases, and judges would better incorporate cutting-edge research into their decisions, their recommendations, and their sentences. Everyone has to grasp the importance of this. Everybody has to assimilate these lessons that we've sought to share in this webinar and in our paper to try to fulfill all of our professional responsibilities. Thank you. And now I'll stop sharing. And I don't know, Anthony, or who's going to be the question moderator.
I would be happy to throw some questions your way. Great. So you don't have to scroll through everything.
Thank you.
Thank you both for a wonderful presentation here. Some very helpful information. One question we have here is if there are particular gold standards that you would recommend for assessing for fetal alcohol syndrome.
I'm going to lateral this one right to Heather.
Yeah, I knew you would.
Yeah.
You know, I wish I could really speak to gold standards. You know what I can speak to, though, is that in the sense of having obviously the expertise outside of whoever you're retained by, and making sure that that individual is doing all of the investigatory work that's necessary to assist you in making a well-rounded, adequate diagnosis or determination.
The only thing I would add to that is the article by Professor Brown and several colleagues that we cite here that lists 5 or 6 things that they believe should be done in every case. I think that's a great place to start.
Absolutely right. Yeah, that's a great article.
What about, we have a question about what should counsel look for in clients, perhaps as a clue or a screener for fetal alcohol syndrome disorder?
Yeah, that is so difficult, again, because as we talked about, there are so many similarities, obviously, between other types of disabilities. But again, as difficult as I personally know it is oftentimes to get early records, let's say, if you're dealing with adults, or to get school records, or to get a hold of hospital records from an early age, that's incredibly important to do because you'll get maybe some indication of other markers. Again, right, the likelihood, let's say, that you're going to see any type of, admittance about use of heavy alcohol, again, hit or miss, or right, even contact family members, right? Do your full investigative job.
And also, when you talk to your expert witness, make sure at the best of your abilities that the expert has access to all this. The best expert witness I've ever been involved with in my life, Heather knows what's coming, is the late Dr. Bob Sadoff, who is a forensic psychiatrist, a dear friend who passed away about 5 years ago. And he said to me the first time he was an expert for me in a case, and I was 25 at the time, so you can figure out how long ago that was. He said, Michael, I want every word that's ever been written about your client. I want everything going back to the time he was in first grade. I want every medical record. I want everything from any social service agency, anything from any Army service records, every single thing. Get it all from me. And that's the best advice I ever got for an expert witness. And that's the advice I will give to anybody here. Get whatever it is that is there. One of the issues, of course, is when lawyers don't know to ask for it. And there's such a range of lawyers. There are, top-ranking criminal defense lawyers, those who specialize in the death penalty are there's some superb lawyers, excellent public defenders. But in many states, counsel is appointed on whim by the local judges. And we know, and I've written about this in one of my books, judges basically, in some jurisdictions, this is awful, appoint bad lawyers because they want the defendant to be convicted and they know the lawyer's going to do a half-assed job. That's a separate issue. I wrote one of my books is called Mental Disability in Criminal Law, and the Death Penalty, the Shame of the States. And in that book, which was published by Rowman and Littlefield about 10 years ago, I go into a lot of that if anybody is interested. Those are some of the issues we have to confront.
Well, speaking of expert witnesses, we have a question here about Daubert admissibility. So how does fetal alcohol syndrome disorder comport with Daubert, especially with error rates and diagnosis? There's a follow-up about aren't less severe cases less reliably identified, diagnosed, but more likely to be raised as a factor in legal proceedings than more severe cases.
The reason I'm laughing is that I know whose question is. He sent me an email 15 minutes before we went on. So I'll say, Dennis, thanks for asking this.
Oh my
The answer is the Daubert game is fixed. Susan Roselle wrote an article with a great title, no Dylan title, but a great title, Daubert Schmaubert. And there have been other articles as well. One is going to be by a guy named Michael, and I'm blanking on his last name. It's going to be in the Michigan State Law Review very soon. It's available on SSRN. Edwin and Winklereed wrote an article. Basically, the prosecutor wins Daubert cases. The criminal defendant loses. On the other hand, interestingly, in civil cases, the defense, who are insurance companies, win, and the plaintiff, represented by trial lawyers, lose. This is so to an over 90% rate. And I've just sort of given up. I wrote about Daubert a couple of times, about Daubert and Cumho. I've just given up on it because I think it's all a fraud.
Okay, wait. I'm so sorry. Are you really giving up? Because I can give a little bit of an answer.
I'm not giving up on anything. Heather, you know that. I was just being rhetorical.
All right.
I've written over the years about pretextuality in the law. And I think the way that courts decide Daubert is a perfect example of that. So the answer is, Dennis, yes, you're absolutely right. There are all these issues that you raised in your question. They don't matter to trial judges. Of course, the issue on top of that is, to what extent are the lawyers in these cases well-versed enough to continue to make the arguments at trial and keep them up on appeal? And that's another very separate, serious issue, doesn't really relate to what we're talking hit on something very important. And it just really troubles me that we're not paying enough attention to it. Heather, do you think I overspoke?
Not at all, no, except that in my experience, by the way, just FYI, in response to the particulars of the question, it's that, I have found obviously things, medical expert testimonies come in under Daubert with a much lower bar, honestly. And, the crux of Daubert, right? An expert can testify to scientific knowledge that assists the jury, right? And really the judge weighs the factors, takes a look at, has the theory of the technique, has the diagnosis been tested, has it been subjected to peer review, right? And, I know you are fully aware of all of these things. If it is in fact Dennis, and he is as well, right? So the potential error rate, right? So keeping that all in mind, I personally don't know that Daubert's gonna be the axe to this. I think that, exactly as Michael said, pretextuality and whatnot, and the judge's just, mental block, once that testimony is then given, is gonna be the axe. But I don't think Daubert is, in my opinion.
I'll just,
For any
before I
more
transition to the next one, I'll just clarify, just for everybody, that we are at the top of the hour, so that if we will stay for some additional questions, but you are free to go. Make sure that you click the link to get your continuing education credits and complete that before you leave, though. With a new court ruling that fetal alcohol syndrome disorder can't be raised as an issue for ineffective counsel if it wasn't raised earlier in the case, is there a way to raise the need for considering fetal alcohol syndrome disorder in death penalty cases later, in cases where the initial attorneys just didn't realize it might be present?
The Shin case was not a fetal alcohol syndrome case. It was about something completely different. So make that clear. This was just kind of a broad rule saying you cannot raise a Strickland issue in a federal habeas corpus petition if it wasn't raised at state court. So this means there's much more pressure at the state court level. Most, not all, of the major cases have come through. Although Atkins v. Virginia was a state case, Hall versus Florida was a state case, the follow-up to Hall Moore v. Texas was a state case. There are some cases that go from the state system right up to the U.S. Supreme Court. The majority of cases, though, where there is some judicial relief, go from the state courts where the defendant loses to the federal courts and a habeas corpus is granted. So that's not going to happen anymore in any kind of Strickland issue. It's not related to fetal alcohol. I think here the responsibility is much more on lawyers at the trial level to know this. And one of the things that I am about to write myself a note on, there's a woman named Elizabeth Kelly, whom I think Heather knows as well, who does trainings all over the country for criminal defense lawyers on mental health issues. I believe Heather has done a chapter for one of her books. I'm not 100% sure. And I'm going to send Elizabeth a note after the session and say, Heather and I just did this. Are lawyers that you train being put on notice about this? Again, you've got, Anthony, one of the issues is you've got lawyers, you've got the best lawyers in the country doing death penalty cases at a very, very sophisticated level. You've got those, some states have death penalty units in their public defender's office and no one ever gets a death penalty. And then you also have the absolute bottom of the bar. I always thought that it was most likely to get the death penalty if you had an African-American or some other racial minority person murdered, was charged with murdering an attractive young Caucasian woman or girl. That always seemed to me to be the gold standard for juries. And it's not, it's in second place. The gold standard is bad lawyers. The bottom of the bar results in the most death penalties. Stephen Bright, one of the greatest death penalty lawyers in history, has written about this. I've stolen his stuff, so it's in all my stuff as well. But, and there's, it's like one of these things, there's no bell curve. It's Twin Peaks. You've got great lawyers and you've got terrible lawyers. There is very, very little in between. And that's one of the problems.
The facts of Shin are so significant in this answer because the real crux of this and what Justice Thomas, if I can even use the term justice before Thomas, but anyway, yes, what Justice Thomas really focused on, again, with Shin, there was so much evidence that was there potentially leading to Shin's the innocence, right? And the fact that, did not actually commit the offense. And Justice Thomas said, look, this wasn't put in, below, and we're not gonna hear it now, right? And so that just truly goes to the point of the competency of the lawyer at the outset to prevent that, situation from occurring.
Sounds like a lot of this comes back to just core training and responsibility of the lawyer in general, let alone on the particular issue.
100% right, Anthony.
Mm-hmm. We have another question about, particularly on the lines of race, are there racial differences in the identification of fetal alcohol syndrome disorder?
I mean, I would expect, Heather probably knows more about this than I do. There's two separate issues here. It seems to me that there are globally, percentage-wise, more cases that have been diagnosed among people who are racial minorities, but that in economically marginalized neighborhood, there's probably less likelihood that people would have ever been tested and evaluated. So in other words, the answer seems to, we know that among Native Americans and Eskimo Inuit people, it's the highest, that African Americans are next. But I believe that in neighborhoods that are predominantly African American, that are economically marginalized, there's simply not as much testing, not as much evaluation. So there's probably even more people in that cohort than we know about. Heather, is that right?
Yeah, I would totally agree with that, right? It's just the quality of the educational services, again, is going to make a major difference, right? What type of interventions are being offered early on?
I mean, one of the things Heather said that at the beginning that was very, very quick, but I thought needs refocusing is, how is this going to change after COVID? When we know there's been so many more people drinking excessively because they've been home for the last several years, and we know about, quote, COVID babies. We have 2 grandchildren who were born during COVID, and it's just very interesting, how that is played out in very, very different ways. But what's going to happen when these COVID babies who were subjected to excessive alcohol intake, when they get to the public schools in another 5 years? I think it's going to be a huge, huge change, and we're going to become much more aware of it.
One of those situations where, I mean, the phrase "time will tell," but only so much that we can know until we actually get to that time.
Agree.
Yeah. We have one question about, given the range of presentation, shouldn't fetal alcohol syndrome disorder be considered only if it results in pertinent functional deficits, rather than a mere diagnosis of fetal alcohol syndrome disorder?
I mean, sure, right? Because the deficits are the crux when we're looking about, in the intersection with the criminal justice system, right? The deficits are what is going to have any impact in mitigation, in a affirmative defense, etc.
In the first insanity case that I ever did, I put on all sorts of stuff, and the judge said, "Mr. Perlin, this has all been very interesting, but how does this relate to the McNaughton rule?" And he got me, and I've never forgotten that.
All right, and I believe the last question we have right here now is, we've been talking a lot about alcohol. One question here is about, can phenobarbital exposure in utero lead to similar symptoms or clinical presentation?
Excellent, and that was running through my head really as I was speaking, because in my head I'm thinking, all right, there's this whole other piece that, again, like I don't have time, but no, absolutely, and that is, that really changes up the discussion though. Or so from what I have read, from what that would maybe change up a little more of, who we're focusing on as maybe more likely to have that effect diagnosis, right? Where is that more in, like, the middle class, upper class type, area where we're looking at, again, what the particular drug of choice and the effect. But yeah, I do believe that the neurological damage, the deficits are going to be very similar. But again, the source is significant in looking at the overarching studies of who's going to be most effective.
I can't remember reading, Heather, you read different cases for this presentation than I did. I can't remember, and I read somewhere between 50 and 75 cases probably, before I did my PowerPoints. I can't think of a single one in which phenobarb was raised. In any of yours, Heather?
Well, so I was reading all like the medical journals.
Yeah, but I mean, this is like an N of about 100. We haven't seen a case. I'm going to go back, and because I'm like that, I'm going to go back and see if there's any.
There might be
FAS cases.
There might be.
It's a fascinating issue, Anthony. Whoever raised that, kudos. Yeah. But I just don't know if it's ever been discussed.
Well, Heather and Michael, I want to thank you so much for everything that you've presented and willing to respond to all of these questions today. Seems to be a little bit for everyone here, our attorneys, our clinicians, and all that. Sometimes you never know when you're going to encounter an issue related to this until it comes, and needing to be prepared is of critical importance for a lot of people in this audience. So I thank you for all the information that you've shared with us here.
And thank you for having us, Anthony. We
Thank you
Absolutely.
very much.
That closes today's Law and Mental Health series. We will see you next week, and have a fantastic rest of your day.
Bye, everybody.
Thank you.